Judgment in the appeal, the Queen on the application of O, and the Secretary of State for the Home Department.
Lord Wilson will explain the decision of the court.
The Home Secretary often detains foreign citizens who have no right to be in the UK until she is in a position to deport them. Unfortunately, these detentions can continue for years. This case is about the Home Secretary's policy for the temporary release of some detainees back into the community pending deportation, in particular those suffering mental ill health. Ms. O is 38 years old and has Nigerian nationality. In 2003, she entered the UK illegally, and later she committed an offence for which she was imprisoned. In 2008, at the end of her sentence, she was detained pending deportation at Yarl's Wood, which is an immigration removal centre for women in Bedfordshire. She remained there until July 2011, when a judge granted her bail. She may well continue to be in the UK even today. In these proceedings, Ms. O appeals against the refusal of permission for her to apply for judicial review of the lawfulness of part of the period of her detention at Yarl's Wood. In previous proceedings, lower courts have considered its lawfulness from 2008 to 2010. This case is about its lawfulness during the final few months prior to her release in July 2011. Ms. O has the misfortune to have suffered protracted mental ill health. In prison and at Yarl's Wood, she was prone to impulsive outbursts, suffered hallucinations, and committed acts of self-harm. She was diagnosed as suffering personality and depressive disorders. At Yarl's Wood, she was mainly treated with strong medication. The Home Secretary's published policy is that those suffering serious mental ill health which cannot be, quote, satisfactorily managed, unquote, in detention, should be detained pending deportation only in very exceptional circumstances. In February 2011, Ms. O's solicitors obtained a further psychologist's report about her. The resulting diagnosis was new, that Ms. O was suffering post-traumatic stress disorder, and the recommendation was that she be referred to one of the specialist trauma-focused psychiatric clinics in London. The report was sent to the Home Office, where, in accordance with the policy, the caseworker should have begun to inquire whether the new diagnosis was correct, and if so, whether the specialist treatment would in fact be available to Ms. O, with a view, of course, to an ultimate conclusion about whether her condition was being satisfactorily managed at Yarl's Wood. Unfortunately, the caseworker didn't do so. Her monthly conclusions that Ms. O should remain in detention were therefore flawed. It is, however, clear that the number and complexity of the necessary inquiries by the caseworker were such that no lawful conclusion could in any event have been reached within the few months prior to Ms. O's actual release on bail. If the Home Secretary's detention of Ms. O during those months was to have been in the exercise of a power to detain her rather than a duty to do so, the result, in accordance with a case called Lumber, decided in this court in 2011, would be that Ms. O's detention during those months was unlawful, but that, because she did not suffer prejudice as a result of it, she would not be entitled to damages beyond a nominal £1. But the Home Secretary argues that in the particular circumstances, she had a duty to detain Ms. O, and that therefore the procedural flaws did not make the detention unlawful. This argument, which is based on a comparison of complex provisions in Schedule 3 to the Immigration Act 1971, was accepted by the Court of Appeal in a case called Francis in 2014. Today, this court unanimously concludes that the decision in the Francis case was wrong, and that the Home Secretary's detention of Moseau during those months was indeed effected in the exercise of a power and was therefore unlawful. Nevertheless, we think that the lower courts were entitled to refuse permission for her to proceed with her claim because it could bring her no practical benefit.
Thank you. The court is now adjourned.